Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address the critical issues facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics. If you've been tuning in, you know we've handled finance and family law, personal injury, workers' compensation, and many more. In our last segments, we were talking about personal injury, and most recently, we started medical malpractice. At the end of every segment, we tell you that we are very willing to address questions from our listeners. And as usual, we do have a few questions, and at this point I'd like to turn it over to Jackie Grasso and to David Bazar of Audette Bazar, Cordeiro Grasso law firm in East Providence. Welcome, and what about that question?
Okay, I'm going to ask the question today. We got a viewer from the East Bay who wrote in, I'm a Rhode Island resident and I got in an accident in Fall River recently. I don't know which law applies.
Okay. It's a two-part question. The first question that we need to deal with is what negligent law or tort law applies. Massachusetts, as we talked about a little bit last time, has a cap that you have to reach in order to receive pain and suffering, $2,000 in medical bills. That law will apply to the case that that woman has because Massachusetts has an interest in what kind of damages are awarded and that type of thing. However, the insurance policy that she has will be regulated by the Rhode Island law. So she'll have med pay, which I'm not sure we talked about last time. We can talk about a little bit in this case. That would cover her, and her liability insurance, if she was at fault, would cover her based on her policy. Now, Massachusetts has PIP coverage, which is a little different, personal injury protection, that would not apply to her because she doesn't have it in her policy of insurance.
And just to be clear, in Massachusetts, in order to recover for damages for your injuries from a car accident, you have to have at least $2,000 in medical bills. Otherwise, you will not recover for pain and suffering.
Isn't just about everything at least $2,000 these days?
Well, not really. Oddly enough, there are some tests, or a hospital room, an emergency room might be about $500 or so.
So if somebody gets into an accident and they go to the emergency room and they have an x-ray and a visit and that's about it, they're not going to probably reach that $2,000 threshold.
That's right.
So the medical bills could be paid under their med pay provisions of their policy, of Rhode Island policy. If it was Mass, it would be PIP. But that's all they're going to recover in Massachusetts. Whereas in Rhode Island, if they do have some pain and suffering that lingers on for a period of time, they can make a claim for that even if they don't reach a certain threshold of medical bills.
Well, we were talking about compulsory insurance last time. You mentioned or referred to med pay, and we also were talking about briefly here personal injury protection. Can you clarify or make the distinctions between the two in Rhode Island and Mass?
Personal injury protection is almost like compulsory, except that it applies to your medical bills. So your first $2,000 in medical bills are covered. It also gives you lost wages. You don't have to pay an added premium for personal injury protection in Massachusetts. That's normal with every auto insurance policy.
It's part of the policy,
yes,
is what Jackie's saying. In Rhode Island, liability insurance is what's mandatory. Everyone has to carry liability insurance, which is insurance that covers the damage you do to somebody else. It doesn't protect you. And we always recommend that you augment that, so you will have to pay extra for uninsured motorist coverage, which we did talk about last time, and for med pay. If you want to cover your own car, that's comprehensive or collision coverage. That's a totally separate coverage or provision under your policy. You should get that too. However, it's liability coverage that's mandatory.
That's the compulsory.
Compulsory. And another aspect of Rhode Island versus Massachusetts, in Rhode Island, the minimum coverage you can have to protect against your own liability is $25,000. It's different in Mass.
I believe it's 20.
20,000 in Mass.
Yeah. And just to be clear, if your first $2,000 is covered by your personal injury protection provision of the policy, that's applicable to your lost wages and also to your medical bills. Relative to the medical bills, if you have more than that in medical bills, that's when your health insurance policy would kick in. If you don't have a health insurance policy, then the PIP will cover, but provided that it's reasonable and necessary care, but then it will cover up to $8,000. With MedPay, if you don't have a MedPay policy or MedPay provision in your policy, your health insurance pays for the bills. If you don't have any health insurance, where do you go from there?
Right.
Where do you go?
Well, if someone else is at fault for your injury, then you can sue under their liability policy and collect back for whatever bills you incur.
And we were mentioning last week, or last installment, so to speak, that often an insurance company will swoop in and say, worry not at all, I'll take care of you, and we'll expedite this, you'll not have to worry. If it is a small issue, how does someone who is on the consumer side really know whether or not there is a bona fide claim, something that's actually going to take time for it to play out versus just taking the seemingly easier route? How do you evaluate that? What do you suggest to a consumer who has to make that decision?
Are you asking a Rhode Island case or a Massachusetts case?
How about both?
All right. In Rhode Island, if you're suffering at all, you have any pain and suffering, discomfort of any type, and it's early in the case, and sometimes the day of the accident, you don't feel it as much as you do the next day or a week later. Yeah. If you settle, right away, as we talked about last time, you cut yourself off. You're done. Although there is a provision in the Rhode Island law that says if you sign a release within 30 days, the release can be voided because the legislature recognizes that insurance companies will try to swoop in and make people, entice them to settle early before they know the extent of their injuries. And you may not know the extent of your injuries within the first 30 days. So if you do that, and you go to a lawyer, it is possible to set that early signed release aside. In Massachusetts, if you're treating and you don't know when you're going to be done treating, you have to bear in mind that $2,000 threshold.
Yeah, the $2,000 threshold.
So out of this, what we could distill is that anyone who has an accident, it's worthwhile for them to wait the day, the week before someone comes in and says, I think it's time for you to settle. It's probably worthwhile to see how the rest of the injuries or pain plays out to then determine what they may or may not do next. Is that the safe?
I think what you're saying is if you aren't feeling too bad and you want to wait it out for a few weeks, a month or so, and you're still feeling okay, you're okay to go ahead and settle without a lawyer. That's probably true. Again, if you've been treating with a doctor and there's an ongoing problem, I've got a nagging pain in my shoulder, my back, my neck, until I was treated by a doctor and knew exactly what that was and what was causing it, I would never settle.
I agree with him, and I always tell people, take the advice from your physician as far as your treatment.
Right.
Your lawyer's not going to tell you when to finish treating. It's going to be your physician because they have the medical information. They have the medical background. So we can't tell people when to stop treating. It's up to the individual.
And this, I guess, is a good, perhaps, stepping stone to what we also started talking about, specifically medical malpractice and doctors' point of either being negligent or not necessarily observing best practices. When a doctor is involved in these kinds of cases, is there any reason that you should be circumspect about when they tell you they should, how much longer they needed to be treated, rehabbed? Is there anything that gets you directly involved with the doctor to determine how long this should play out that will then affect how you're going to take care of a case?
Are we stepping into the world of medical malpractice now?
I think so, David.
Okay. Well, if we're going to do that,